everyone. Clearly, I ran out of time to talk about both intentional torts and negligence in the same PowerPoint. There's a lot to talk about, but I really want to spend a few minutes and go over the elements of negligence with you. In the first PowerPoint, we talked about how tort claims are analyzed using elements, or another way to look at that would be, what is the checklist of what a plaintiff in a civil tort case must prove in order to hold a defendant liable? So we went through the element checklist for defamation, for false imprisonment, and also for interference with contract. Those are all examples of intentional torts because the defendant's conduct in each one of those examples is said to be intentional. For defamation, for example, even if the defendant didn't mean for his statement to harm the plaintiff, the defendant meant to make those statements. You don't accidentally say, Bob's Pizzeria was terrible pizza. You mean to say that. So that's the intentional conduct that we're talking about. The word negligence clearly means something different. In fact, a lot of us use this word in our everyday language. We say, well, that was being negligent. So what is it that we mean by negligent conduct? Negligent conduct, I think to most of us means when someone doesn't act the way that they're supposed to do, the way that they're supposed to act, they're being negligent. So what I'm going to focus on here is the elements of negligence. We're also going to have an opportunity to talk about negligence on our discussion board this week, because I'm asking you to watch part of the documentary called Hot Coffee, where a woman became very famous because she was burned by hot coffee that she bought at McDonald's. So you might have heard about this case before, or you might never have, but it's an opportunity to learn about her side of the story. And that was also a negligence case. And lastly, we've already talked about negligence because Kuhn versus PubZone, as we've already referenced in this unit and earlier this semester, is also a negligence case. As was the first question, one of those essays on your first exam, when I asked you to consider, should the Mandalay Bay Hotel be liable in tort to the victims that were unfortunately injured, or for the families that lost somebody when the gunman shot from the window into the concert below. That was also based in a negligence case. Okay, so here on this slide, I've clearly put up for you the negligence checklist. Number one, a defendant must be shown to have a duty of care to the plaintiff. That should actually sound really familiar because we've been talking about duty of care a number of times this semester. Second, the defendant has to breach that duty of care, meaning does not live up to his obligations. Again, is something we've talked about with that concept of breach of fiduciary duty. Third, the plaintiff must show that the defendant's breach of a duty of care caused, and then the fourth element is injury. So I'm just going to spend a couple of minutes going through each one of these. I also put a picture here of a caution slippery when wet floor, because one thing I want to mention before we go any further is that negligence is really the classic tort of somebody slipping on a banana peel at a grocery store and getting injured. The store has a duty of care to keep its customers safe from injuries. That's why they wipe the floor. That's why they send employees around to make sure nothing's spilled, because store owners have a duty of care. If the employees just ignore a spill on the floor or leave it there for hours and then you slip and fall on it, well, the leaving the banana peel there for many hours is the breach of the duty. When something's spilled on the floor, you're supposed to clean it up, at least, maybe not within a minute, but within a reasonable period of time. And then if you slip on that banana peel, that leaving of the banana peel caused your harm. So keep in mind the classic slip and fall scenario when we talk about negligence. Okay, so element number one, I thought I broke these down into slides. Element number one is duty of care. So as we just mentioned, all stores owe a duty of care to its patrons and customers. We also talk about duty of care in other contexts as well. One of the other matters that you'll see in the video for the discussion board this week has to do with the medical profession. Doctors also owe a duty of care, and when they violate that duty of care, that's what leads to medical malpractice lawsuits. Drivers have a duty of care. When was the last time you drove a car? When you drive a car on the road, of course you have an obligation to follow the traffic laws, but you also have a duty of care to be a reasonably safe driver. So that includes following rules of the road, looking out around you, not texting while driving or changing the radio station or engaging in any other distracting activities. That's your duty of care as a civil side, not just because the law tells you you have to, but you owe that duty of care to be a reasonably safe driver to everyone else on the road, whether they be pedestrians or other drivers. And certainly businesses owe duties of care, as we've seen in the Kuhn example or the Mandalay Bay example. So we know that entities have duties of care. What do we mean by breach? Breach, as we learned with a breach of fiduciary duty, is when the store owner has that duty of care that's up here to act a certain way in a reasonably safe way, and the breach of the duty of care is falling below that standard of care, not living up to what the duty of care is. But notice that negligence law doesn't say, businesses, you have to be perfect all the time. Nobody can ever slip and fall, nobody can trip, nobody makes mistakes. We don't hold businesses to if somebody slips, then the business is automatically liable. We know that. That actually would be what we call strict liability, automatically holding somebody liable. So this idea of duty of care and then a breach of duty of care is rooted in two words that I know you're familiar with. Number one is reasonableness, and number two is foreseeability. Business owners have a duty of care to act as reasonable business owners in that situation, to guard against foreseeable harms. And they breach that duty of care when they don't act reasonable and don't take reasonable steps to prevent those harms. Breach doesn't mean you didn't act perfectly, it just means you didn't take any steps. So to bring it back to the banana peel example, if a store owner or an employee sees a banana peel on the floor or some other slippery substance and just says, I'm too busy to do that, I'm gonna go over here and do something else, and leaves the banana peel there for an hour or 2 hours, and somebody slips, that's probably a breach of the duty of care. But do we expect the employee to stand there 24/7 staring at that floor waiting for something to fall? No. There's that reasonable period of time that the store has to notice the spill and clean it up. That's what we mean by a duty of care and breaching that duty, not living up to the reasonable standard. Now I want to focus on the third element, causation. And this is a really interesting element because causation, we usually think this is the easy element, right? The breach causes the harm. But actually, causation can be really complicated. We talk about two types of causation. One type is actual causation. This is what we refer to as connecting the dominoes. The banana peel fell on the floor, the store employee didn't clean it up, and it led to somebody's injuries. That's what we call actual causation, meaning you can link the harm of the victim, or the plaintiff in that case, to the defendant's negligence conduct. That's actual causation. The harder question is proximate causation. And proximate causation means that the defendant is liable only for those injuries that are within the zone of foreseeability. There's that foreseeability word again. Your book actually references the most famous case as to proximate cause. It's called Palsgraf versus Rhode Island Railroad. And it is the case that said that the defendant is liable when his conduct caused the harm, but only for harms that were reasonably foreseeable. It involved a case, this is a really funny case from like 100 years ago, where a woman was standing, true story, on a platform for a railroad. And she's over here, like figure the far right side, and she's waiting for her train. And in the meantime, a train pulls into the station and then it starts to pull out of the station. And not her, she's waiting for another train. But there's another guy and he wants to get on this train. But the train's moving and he's running late. So it's the 1920s. What does he do? Instead of waiting for the next train, he starts to run, and he's running as fast as he can to get on the moving train. The conductor sees him, true story, goes down and pulls him up onto the train to get him onto the train. I don't actually think this would happen today. and gets him on the train. But before they can go any further, he happens to be carrying a bundle, and he drops the bundle, and guess what was in it? You'll never guess. Maybe you have because you read the case. He was carrying explosives, and the explosives set off a little explosion at the train station, and it reverberated all the way down to the end of the platform where this woman was standing some 300 feet away. And standing next to her was this giant clock tower, and the clock tower fell on her and injured her. This is a true story. So she sued the railroad. Now, could she say that the railroad's negligence in grabbing this other person and getting him on the train, leading him to drop the package, which caused the explosion, which caused the clock tower to fall on her, are all those dominoes linked? Yes. But was that particular harm foreseeable? Probably not. So this was the case that established the notion of proximate cause, meaning the type of harm that happened was foreseeable compared to the defendant's negligent conduct. So that's the part about causation that's a little bit tricky. The last element is harm, meaning the plaintiff must show that he was harmed by the defendant's conduct. Harms can be financial harms. Harms can also be physical, right? Your tort, if I'm in an accident, can injure me physically. I might have medical bills and hospital bills. Maybe I missed work. Those are all types of harms that I can suffer. Speaking of, the last piece I want to talk about with torts is recovery and damages. And this is something that's also crucially important for businesses to understand. If they are sued, what can the business be liable for? And this is also heavily discussed in the Hot Coffee documentary portion that I want you to watch. There are two types of important tort damages. There's both compensatory damages and punitive damages. So compensatory damages include the out-of-pocket expenses and harms that a person suffers. So that would include time off from work, medical bills, out-of-pocket expenses, and it would also include, used vacation time. And you'll see in the example of a number of other compensatory damages. It would also include just general pain and suffering that people suffer from a tort, like if you have anxiety as a result of an accident you've been in that was someone else's fault. That's compensatory damages. Punitive damages, note the P, punitive means to punish. These are what you hear about in the news, the multi-million-dollar tort lawsuits, because you can't send a business to jail for its tort conduct, but you can hit them where it hurts, and that's their pocketbook. So you can recover only in limited cases punitive damages, and that means a large damage amount to really send a message to the defendant that your conduct wasn't just a little bit bad, it was really bad. I would like us to discuss damages more on our discussion board. All right, that's the end of PowerPoint number 2. I really look forward to talking about negligence and damages on our discussion board, and I look forward to hearing your thoughts about the Hot Coffee documentary.